be seated. We have two cases this afternoon. First one up is 1424-00840-CV. Alexi Standen individually and Nina Standen individually, and Alexi Standen and Nina Standen as next friend of Diana Standen minor versus Mark Moore and Midstream Transportation Company, LLC, and JLB McAdams Enterprises and Asha Transportation, Inc. Appellants ready?
Yes, Your Honor.
Yes, Your Honor. All right. Appellee? Appellee ready. Appellant, you want to reserve some time for rebuttal?
Yes, Your Honor. Reserve 5 minutes.
All right. I got that down. Approach the lectern, sir, and let's get started.
Thank you, Justices, and may it please the Court. This case today was an appeal that really should have resolved on a phone call on July 22nd, 2023. What happened in that moment was new counsel for the appellants appeared in the case for the first time informally, not formally, but informally, and made a phone call to the appellee's counsel requesting time for an ability to respond to a no evidence summary judgment. A no evidence summary judgment which was never served on the stand-ins. The appellees have no true dispute to that fact. We know this because the certificates of service on that very document states that they were aware Mr. Ogle, the prior counsel for the appellants, had deceased. They knew that he died in December of that year. They filed that motion in February knowing he was deceased, and they serve it on him knowing he is deceased.
What would you suggest they have done at that point?
What the appellees should have done at that point was serve that process upon the stand-ins themselves. That was the appropriate remedy as they became pro se. Rule 21A is very clear. It gives 3 avenues for service. One is on the party themselves, the second is on an authorized representative, and the third is on an attorney. Without an attorney, it devolves to a pro se matter, and they can serve on the appellees themselves. Furthermore, if they had a concern, say, for example, the rules of disciplinary procedure, the rules of disciplinary procedure specifically authorize service on a party as authorized by law.
Did they have the stand-in's address?
The stand-in's address, I'm not aware if they had the stand-in's address, but that would be part of the diligence in making the process of service something that they needed to do. Or they could have reached out to any other individual, they could have run a background check, they could have hired an individual. They could have filed a notice of publication as well. These are all avenues that were available to the appellees, which they did not undertake.
When did your clients learn of their attorney passing?
We do not know, unfortunately, when they learned of the attorney passing, and I will not represent to the court that I am aware of that time. What I am aware is that in June of 2024, the appellant's new counsel received a file. The file was physical in nature. That was discussed at length in the hearing for the case. We know that counsel admitted that she had the file and that she did not ever particularly review it in depth to a degree to find this motion if it existed. But we also know that he was deceased prior to the filing of this. So we don't know what's in the file.
So it seems to me that we have it seems to me that the facts are undisputed to the extent that we have facts. And then there are a lot of unanswered questions.
The facts are undisputed to the extent that we know what the sequence of the events are. The disputed facts are the nuances of what happened. For example, what is in the file? No one knows.
Yeah, it's a question I had.
But we have some evidence of what's not in the file.
Wouldn't the motion that they filed had been in the district clerk's website? I mean, I know that, when you're in private practice, you can log on and search the case and look at any filings that are available. So why is it that she waited until the day before to file the motion for continuance? She had access to the file in June. And I'm not saying this is in the record, and my question to you, is there anything in the record that suggests that lawyer did any of that when she had the physical file in June?
There's no thing in the record that she did it in June. There is in the record that she did it in July. July 22nd specifically was the date that she, in reviewing the file that she said she did, she then went onto the district court's record website and found for the first time the notice of this hearing.
Had she been hired at that time?
So that would be a statement we don't know the exact details to, but the hearing, I would say the answer is no. Based on her representation to the court, and that was specifically on the clerk's record, page 176 to 177.
So is that evidence?
Yes, it was submitted as part of the motion for new trial.
Meaning her statement?
It was her statement to the trial court at the hearing on the motion for summary judgment. The trial court specifically inquired this exact question. When did you get authority? I believe the trial court said, just out of curiosity, when did you get authority? She responded Wednesday or Thursday, I believe, and she believes it was Wednesday, which would have been 7 days prior to the hearing on the continuance itself. So her statement to the court is, I had true authorization 7 days before. I acted as a diligent attorney would have done, though, when I saw a problem for a potential client. Therefore, I reached out to them and introduced myself, requesting the extension on their behalf. I think that was a diligent effort to undertake. And I think it comes back, though, to what constructive notice and actual notice mean in the context of these services of motions. It's something I don't think any court has ever really had to devolve in or dive down. When do you need, which one do you need? Why do you need it? Because it's so boilerplate moment. It happens every time. You serve the motion on the party gets it, they receive it. If they don't show up, you have a certificate of service. The case law says prima facie evidence that it was served. This is a different problem. What happens here is appellees serve a dead attorney. The prima facie evidence of the certificate of service is we know we serve the wrong person. So the stand-ins don't have constructive notice of this. They have to have actual notice of this. And that's why we cited to that case, the Red Bluff case, about a 306A motion. That is not a particular motion that involves this case, but the Texas Supreme Court went out of its way to really dive into what is actual notice? What does that really mean? And they went to the Black's Law Dictionary and they dove in. Actual notice is not going to be construed in these crazy ways. It's just going to be, did you know? When did you know and how did you know?
Did the stand-ins get a reset with the date for the notice of summary judgment hearing?
They did not get any notice of the reset.
Not from the court?
Not from the court. In fact, we highlighted this in the brief, Your Honor. The specific notices that went out was on the day they filed the no evidence summary judgment, they also filed a motion to continue the case. That time they said an adequate time for discovery had not occurred. We need additional time. And they in fact said it is impossible because their attorney is deceased. The court resets it about a month later, and then about 2 weeks after that is when they notice the hearing, again serving the dead attorney.
So how can we decide whether there was an adequate time for discovery when we don't know what's happened in this case? Like, we don't know what discovery has happened. There was a reference to, I think, the fact that the plaintiffs had responded to interrogatories. Had the plaintiffs served any discovery?
To the best of our knowledge, they did not. But I think that the court can actually just look at the McInnes factors that we talked about at length. And when you look at those, the first one you look at is the nature of the case. It's a car wreck case with a commercial motor vehicle, allegations in the case, direct negligence claims, training, liability for the training for the negligent entrustment of the vehicle. These are not boilerplate run-of-the-mill cases. They involve in-depth and complicated discovery, matters that will be hotly disputed as the case continues on. We know that the evidence necessary that would have been required to respond to this summary judgment was a much higher standard than normal. They would like to propose an affidavit would have been enough. That is incorrect. In reading their no evidence summary judgment, there are 63 individual points for no evidence.
Except trial counsel said that she could have responded within an hour or an hour and a half at the hearing.
Yes, and trial counsel did say that she could get an affidavit, but the point that we're making on the appeal is a different problem. It's that that affidavit might have been sufficient for some, but certainly not all of those 63 different points. For example, what good would an affidavit of a plaintiff be in a case saying, I believed he was working at the time of the crash? That's a tantamount to no evidence. So the nature of the evidence necessary would still have been insufficient under that standard for all the claims left. the length the case was active. This case was active for 6 months. That is the record. All counsel appeared in this case in about June. That's when Moore and Midstream had fully answered in the case. Mr. Ogle dies 6 months later. The case then goes inactive for 8 months. It was longer inactive than it was an active case. The length the summary judgment was filed. The summary judgment was filed for a long period of time. That is true. But the problem is it was filed for months with nobody knowing. And we know that July is the first time the stand-ins have an affidavit stating that they became aware of this issue. Did they move for stricter deadlines in this case? No. They specifically requested a brand new DCO, new discovery deadlines in the case, because they knew that they needed more discovery. That was part of their motion.
In the motion for continuance, aren't you required to say exactly what discovery is needed and whether it's material, and you know, there's a lot to that rule. How do we deal with that?
I believe, Your Honor, when it comes to the case for what you're required to tell, that is correct in a general sense. You are required to do that. But in a more positive sense of the holistic view in this case, what more could they say than that we needed to do everything if nothing had been done? We needed to do the depots. We needed to send discovery. They needed to do everything to respond to these 63 points. It would have been a tantamount to insanity to make them have to list out possibly every possible thing they could have done. But I think it was sufficient that they did bring the continuance to the hearing and notice of the trial court, who, in an ironic twist, believed there were procedural issues with hearing that motion. Thank you.
May it please the court. Your Honors, having reviewed the 4 questions that the court sent to the parties yesterday, and I want to thank the court for that guidance, in listening to counsel's opening argument, I plan to focus on 2 main points, and I'll cover the 4 questions that the court sent to the parties. First, I want to talk about whether or not the 21A notice challenge, which was raised for the first time in the motion for a new trial, is properly before this court. And that really addresses the scope of the appeal and what are the proper issues before this court. And the first main issue, I'm going to address the court's questions 3 and 4. 2, I'm going to address the merits of the 21A notice issue. Again, the first time notice, not getting the 21 days, the first time that challenge was made was in the motion for a new trial. We do not believe it's properly before this court, but if the court reaches it, there was sufficient notice. The evidence shows that there was notice in June of 2024, and so the trial court did not abuse its discretion in granting the motion for summary judgment and denying continuance.
Did they have a lawyer in June of 2024 who could take actions on their behalf?
Yes, based on the sworn motion for continuance that was filed by new counsel, and that's Clerk's Record 133.
I thought that she was hired. You know, the testimony I think her what would usually be argument of counsel, I think, is evidence, because she owes a duty to the court, and she was talking about her own actions. Do you agree with that?
Not necessarily, Justice. So 2 points on, number 1, the evidence as to when new counsel was hired, had the file, and then 2, whether or not the unsworn statements made at the hearing are evidence. So with respect to the evidence, we have, and I'm just talking about, Your Honor, the evidence before the court at the summary judgment hearing. There was additional evidence at the time of the motion for a new trial, and I think the court should look at just the evidence that was before the trial court at the time of the August 6th summary judgment hearing. So there was 2 pieces of, well, there's 2 items that were before the trial court. First, the sworn motion for continuance. That's Clerk's Record 133. It's a very bare bones sworn motion. But the relevant language in the motion is, I took over the case in June of 2024, and that's counsel. Counsel representing, making a sworn statement, she took the case in 2024. And then you do have statements that were made during the hearing. Those are unsworn statements, and I don't think that unsworn statements, I don't believe are evidence. And then 2, and probably more importantly, all of this evidence goes to whether or not there was notice, and those disputed facts, I think the trial court acted as the fact finder. So any of the evidence that was in conflict, that goes to notice, that goes to the attorney-client relationship and when there was an attorney-client relationship. I think those were disputed facts for the trial court to decide. There was no request for findings of facts or conclusions of law that were requested. So any implicit finding, if there's evidence that supports an implicit finding that supports the judgment, I think this court has to give deference to. And so because there is evidence that she took the case, which I think the trial court, the evidence supports an implicit finding that she had the file, all the contents of the file, and there was an attorney-client relationship by her taking the case in June of 2024. So, Your Honors, I'll get to the first point, which is why we believe the notice challenge is not properly before this court.
Can we stop for just a second so I can, because I think I'm a little bit lost, so I need you to clarify this, and we can do it very quickly. What you're saying is the statements of counsel during the hearing are not evidence.
I think that there are unsworn statements, and I think the trial court, acting as the fact finder, could have accepted the statement in the sworn motion and rejected and not accepted the unsworn statements in the hearing, acting as the fact finder.
I understand that. So the statements that she had the case in June 2024 came from the affidavit?
From the sworn motion for continuance.
Sworn motion for continuance.
So you want us to discount the fact that she didn't have the authority to send any documents on behalf of the client until July or a couple of days before the motion for summary judgment hearing?
Well, respectfully, Your Honor, I don't know that this court can discount it. I think that based on the standard of review, those disputed facts, the trial court had the discretion, acting again as the fact finder, to resolve any conflicts in the evidence. So as to, again, both when the attorney-client relationship existed and when the file was received and the contents, I think those were disputed facts for the trial court to determine. There was conflicting evidence, including what was in the sworn motion and then unsworn statements that were made during the hearing, and the trial court could disregard or not accept as true the unsworn statements at the hearing and take as true what was said in the motion, which was the case was taken over in June of 2024. And so long as there's evidence to support that implicit finding, which is the file was received in 2024, she took the case. Trial court, I think that's evidence to support the implicit finding that there was an attorney-client relationship in June of 2024. And this court, again, the standard of review requires this court to give deference to those implicit findings because it's supported by the evidence.
Counsel, the folks on the other side mentioned that, and you weren't the trial counsel in this case, it wasn't your firm, but the counsel at the time at the trial level knew that the trial counsel for these parties was deceased, still sent it to an email for eServe for folks that at a firm that they knew were deceased, and also characterized that y'all took no action to try to have the actual now pro se from their position appellants served in any other kind of way. Do you think that was appropriate?
Your Honor, I'm not sure if it's appropriate for me to say what was appropriate or not. I mean, I can only tell the court, one, what the record shows, which is the prior lawyer did pass away. The only method that, and again, this is just based on the record, service was attempted was through the e-file system. And one question that Justice Boatman asked was whether or not defense counsel had an email address or any sort of contact information from of the plaintiffs. And the answer to that is no. And that is, it was in Clerk's Record 207. It's a filing by defense counsel where he makes the affirmative statement, we didn't have an address for the plaintiffs so that we could serve them.
The rules of disciplinary procedure allow, I think that's what it is, 13.02, they allow any interested person may petition a district court in the county to assume jurisdiction over the attorney's law practice. And Texas Lawyers Creed says, I will not serve motions in any manner that unfairly limits another party's opportunity to respond. And I just am not really comfortable with how this all went down.
No, and Your Honor, I wasn't involved in the trial court.
I know you weren't.
And you know, if I were there, if there was a do-over, I probably would have done it, you know, differently. And that's all I can say on that point.
Yep.
All I can say is what the record shows was that it was e-filed. Defense counsel knew that the lawyer had passed away. But what I will say on this point is that is a challenge to service to defective service, and this goes to my first point, and I think some of the questions that the court sent to the parties, which is that challenge before this court? Is the challenge to service properly before the court? And we believe it's not, because it was first raised in the motion for a new trial. And this court addressed this issue in the Rios case, as well as the Emanuel case, which was in the letter sent to the parties yesterday. This court adopted the legal principle that if you have a challenge to service of a hearing, notice of a hearing, that's untimely, but you still have a chance to go to the hearing, then you have to file a sworn, it can be a motion or an objection, but in writing, supported by an affidavit, that you are challenging improper notice, defective service under 21A, and you didn't get your 21 days notice.
So it says supported by affidavit evidence. Does that mean affidavit evidence about the lack of service of the notice of hearing, or does it mean affidavit evidence about the reason for your motion for continuance, meaning?
I think what Rios
discovery?
and the Emanuel case require is, I mean, it can be in the form of a motion for continuance, it can be in the form of a motion for leave, but I just think it has to be a written document where you are challenging whether or not you got 21 days. So I got, you know, in the case of Rios, it was 7 days, but I think the writing has to say, I did not get my 21 days notice, it's defective service under 21A. In Rios, the party got only 7 days notice of a hearing. He showed up, but did not challenge, he asked for continuance, but did not challenge specifically under 21A, or that he did not get the 21 days notice. It wasn't until the motion for a new trial where he challenged service that he didn't get his 21 days. And what this court said in Rios, and Emanuel says the same thing, is that if you have a challenge to service under 21A, then you've got to have a sworn document saying, I didn't get my 21 days. Because Rios did not, this court did not analyze the service challenge. And the same applies here. We do believe there is notice, and notice was in June, and I'll get to that in a minute. But the point here is that Rios and Emanuel required the plaintiffs to file a sworn motion, a sworn document saying, I didn't get my 21 days. I wasn't served in compliance with 21A, and that was not done. Now, there was a motion for continuance that was filed, but it was never raised in the motion for continuance. The first time it was raised was in the motion for a new trial. And I would invite the court to compare the two motions. The motion for continuance only says, I need more time so I can get written discovery and for depositions.
So wasn't there a motion for continuance earlier by the defense firm at the trial court level? And they said that counsel's passed away and it's impossible to go forward at this point. Essentially, that's a summary of it.
Sure.
And after that point, how much actual discovery occurred?
I don't think the record reflects how much discovery was done.
So,
and on that point, I would say, Your Honor, there is a lot of missing information. Justice Boatman said, well, how do we know how much discovery was done? How do we know there was an adequate amount of time? It's the appellant's burden to bring forth to this court the record to support whether the relief they're requesting for the court. And that record is not before the court. And so to answer the court's question directly, we don't know. The record doesn't reflect what discovery was done. But the test is if there was an adequate time for discovery. And so when you look at how long the case had been on file, a year and a half, it was a simple case. It was just a simple car wreck case.
So you, not you, the no evidence motion for summary judgment pointed out 63 missing pieces of
It was
evidence.
very thorough, Your Honor.
So
it
that doesn't seem like a simple case.
I mean, when you look at the facts, it is a simple case. There were a lot of points. It was a very thorough motion. We do believe that there was notice again in June, and we do think that there was sufficient time. In fact, by new counsel's own admission, it was going to take her an hour and a half to do a response to the motion.
Is that, are we saying that's a judicial admission, or?
I think it's just, I mean, I think it was something for the, so again, this is on the issue of the motion for continuance, whether or not the trial court abused its discretion. So this was all the information that the trial court had in denying the motion for continuance. And then this court analyzes whether or not it was an abuse of discretion. So the evidence before the court was, file was received in June of 2024. We also know that by the time the paper file got to new counsel, both the motion and the notice had been opened. And I think that's enough information for the trial court to make an implicit finding that both the motion and the notice were in the file. It's not for me to resolve those conflicts in the evidence, nor this court, but that evidence does support that implicit finding. But the evidence before the
But,
trial.
I'm sorry, isn't that evidence that you're pointing to actually argument of counsel? Because what evidence was there in the record that, you know, all this that you've been saying, that the motion would?
I think that, so at the time of the summary judgment hearing, the file, the new lawyer taking over the case, that was evidence in front of the trial court. Other unsworn statements that were made, and it was argument made to the trial court, for instance, when the trial court asked, well, why didn't you've had the file since June, why didn't you file a motion for leave? Well, the response was, I thought, you know, that the continuance would take care of that. Well, how long will it take you to draft a response? And the answer was an hour and a half. I think all of that should be taken in consideration in determining whether or not the trial court abused its discretion. And then Rule 252, which was raised. 252 requires when a party is asking for a continuance of a hearing to meet certain requirements. So if you're asking for depositions, you have to give the names. That wasn't done. You have to give the anticipated testimony of the deponent. That wasn't done.
So is 252 an absolute rule? I mean, what if, you know, what if this were the same, this is a total hypothetical, but what if she actually had come onto the case a day before the motion for, you know, the new evidence summary judgment?
I mean, I think it goes to whether or not the trial court, framing it in the standard of review, I think it goes into this court's consideration as to whether or not there was an abuse of discretion. So again, that was raised to the trial court, 252 wasn't met, and then if you apply the McGinnis factors, again, it's how long the case had been on file, year and a half, the motion had been on file for 6 months.
How much of that time had there been an actual living attorney handling that file?
It was filed in, you make me do math offhand.
Sorry about that.
10 months in the month of, in the year of 2024, and then, and again, we don't know when the plaintiffs were informed of their attorney's death.
Wouldn't you agree from the defense's motion for continuance that we're not there from, I guess it was maybe February of 2024? They said they weren't ready. There was no attorney at that point.
I think they were saying they were not ready for trial, Your Honor.
Right.
Because, you know, for instance, the plaintiffs hadn't even been deposed, but for purposes of
So there was a lack of discovery.
Which is not the test. The test is an adequate time for discovery. Not, if the calculus was if the question was, we haven't done enough discovery, then cases could be pending for 5, 6, 7 years. The test is an adequate time for discovery.
But don't we have to look into whether there was a living attorney at that time, or they were pro se? I mean, like, it's sort of like nobody had the baton, you know? Mr. Ogle had it, and then it just fell.
I think there's 2 questions that the court should answer in this case. The first is whether or not the notice challenge is even properly before the court, which we believe it's not, because it wasn't challenged until the motion for any trial. That's the Rios case, that's the Emanuel case. But if the court does consider the notice challenge, we believe that there's evidence to support the implicit finding that there was notice in 2024. Again, no request for findings of facts or conclusions of law were made or requested. And so if the evidence supports the implicit finding that there was notice in June, and I think the evidence does support the implicit finding that there was notice in June, because again, the files were open, paper file was obtained in June of 2020.
And I really appreciate your timeline, by the way.
Yeah.
But I do want to
Indeed.
ask one other question, which is, are you saying it's actual notice or constructive notice, or do you meet either of those
I
standards?
think that I think it's sufficient notice. I mean, that's the way that we phrased it. There is, you know, the other side has alleged that the first time actual notice was obtained was July the 22nd. And one thing I want to highlight about that is that the notion that actual notice was first, you know, received was July the 22nd. That was not part of the summary judgment proceedings, and that's the reason why we say in our brief, this is not a notice issue. Notice was not raised during the summary judgment proceedings. It was about getting more discovery. So the notion that actual knowledge happened on July the 22nd, you don't see that until the new trial motion. You don't see that in the motion for summary
I'm
judgment.
less concerned with the notice issue than I am with the, and I know you're out of time, the rule that says adequate time for discovery. We know that the plaintiff's lawyer was deceased when? December?
December 2023.
Okay. And we know if we take your position that trial counsel for the plaintiffs had the file, or take her position in the sworn motion for continuance, that she took over the file in June, then from December to June, there was no lawyer that reached out to your firm or no lawyer that you knew of was working on the case. Is that correct?
That might be defense counsel, that's correct.
Okay, so then we can presume that whatever was going on in the case from December to June never happened, and that truly from June until the motion for summary judgment hearing, you know, from June until that date, perhaps there was discovery conducted, perhaps there wasn't. The record is not very clear on that point, but we know that from December to June, nothing was happening in the case because the plaintiffs didn't have an attorney.
We don't know that, Your Honor. We don't know when they had an attorney, and again, that's just missing from the record, and I believe that it's the appellant's burden to do that. But on, I understand that you're struggling with the element of inadequate time for discovery, and that's just one part of it. I think the trial court considered both the McGinnis factors and Rule 252. I don't think you're going to hear any dispute that the plaintiff's motion for continuance did not comply with Rule 252. So I think there's no abuse by the trial court in denying the continuance motion based on failure to comply with 252. Now on McGinnis, the inadequate time for discovery is just one element. The other elements also are how long the case had been on file, the complexity of the case, how much discovery, and then again, inadequate time for discovery. A
So
lot of those
McGinnis-
elements we don't have the record for. And
the
that's
McGinnis elements assumes that there is an attorney working on the case, where in this case, we cannot make that assumption.
That's a difficult question
Yeah.
to answer. Well, because again, it's the appellant's burden to bring the record, and I feel like that's treading over into making fact findings, which I think again was in the sole province of the trial court, and the trial court considered all of that. And I guess the one other thing I'll say on that point is when you look at the evidence to support the implicit findings, and obviously by denying the motion for continuance and granting the motion for summary judgment, the trial court believed that an adequate time for discovery had passed. And even if you look at the dialogue between the trial court and plaintiff's counsel towards the end, there was more, I would say, disclosures made by the plaintiff that I think, plaintiff's counsel that I think were troubling the trial court, and probably the reason why the trial court denied the motion for continuance again. You had the file in June. Why didn't you do something else? And the response was, I thought the continuance would take care of it. I thought the continuance would take care of it. How long would it take you to draft a response? An hour, hour and a half. Your Honors, I'll just do a brief conclusion if I may. Obviously, I'm asking that this court affirm the summary judgment, applying the appropriate standards, which standards of review, abuse of discretion, deferring to the trial court's implicit findings. We believe that the summary judgment was properly granted, continuance was properly denied, and we would ask that the court affirm the judgment. Thank you.
Thank you, counsel. Rebuttal.
Yes, Your Honor. Well, Justice Bridges, you asked a very simple question: was the service of that motion proper? No. I'll answer. The answer is no. Service of that motion for summary judgment was not proper to be served the way it went. The counsel said if there was a do-over, she thinks it would be done differently. I agree. It should have a do-over. It should be done differently. That's what we're here today to do. She says that this was a very thorough motion. I have responded to 500 no evidence summary judgments in cases such as this one. I have never seen one with 63 individual points of known evidence. They just say no evidence of direct negligence, they list the causes of action, they move on. I've never seen one say, you don't have evidence that I was in the course and scope of my employment when I was driving my vehicle and I did not fail to keep a proper lookout. I've never seen someone go that far. This wasn't a thorough motion. This was gamesmanship. Moore and Midstream knew exactly what they were doing. And they told you. They told you they knew. They wrote it in the certificates of service on the motion. We know he is deceased. We're going to serve him anyways. They knew they were pro se. That's why we see a 63-point motion. Pro ses don't understand. That's abnormal. That would be strange even for a seasoned practitioner to see. That would require a lot. The Emanuel case, I think, really helps our position. It seems to imply this waiver, but I look at the Emanuel case and I see how it's written out. And the problem with the Emanuel case is it doesn't seem to lay out the law very well. It just kind of gets to the answer. But it cites in footnote 3, this Negrini case versus Beal. It says that the non-movement waived the complaint when the non-movement received notice of the hearing, appears at the hearing, filed no controverting affidavit, and does not file a continuance. Well, we start at the top. Did the non-movement receive notice of this hearing? No. We know that.
Well, she came.
She did appear, but I think this is an essential element to the problem. These cases, especially like Emanuel, there's no contention that he didn't get something. There's nothing in here. Actually, it was the concurrence of Chief Justice Frost in the same case that mentioned that he supports the decision of the court, but the court really should have just gone that they didn't abuse their discretion for denying it because he didn't actually present any evidence that he didn't receive it. This is a different problem. We presented evidence, there was nothing. And Chief Justice Frost kind of lays out an interesting problem of these kind of cases, but I don't think intentionally. He says that the error preservation precedent says that if you don't have notice and you don't show up, a motion for new trial is perfect to preserve. But if you don't receive notice, or allege you don't receive notice, but show up and then talk about it, you can waive it. This seems very peculiar, if not strange. How is it that Ms. Pleisance, by showing up and doing her job, could have actually more prejudiced her clients than not showing up at all?
Because she didn't tell the court that she didn't receive notice. So the court in that case assumes that the lawyer who did not get notice shows up. We're assuming that they in fact got notice, and then will make an objection or make a statement, a position to the trial court that they didn't receive the notice. So we are assuming that the lawyer is going to take that position and that the trial court will hear it. That didn't happen in this case.
Well, and that didn't happen for one very big reason. The trial court refused to hear the motion for continuance at that hearing. It was beyond the scope of the point that the trial court did not want to hear it. The trial court said, I saw you filed it yesterday. There's a 3-day notice for this, and if you didn't do it correctly, despite the fact the trial court could waive that notice, they were all there, they all knew why they were there. It could have been done. The trial court just declined to go for it. In fact, they said, we're not going to talk about that today. We're going to move on. And then the trial court unilaterally also denies the continuance later. So the trial court attempts no attempt to hearing and then denies it as well. But even if, Justice Antu, your position was the way it should be, that would go back towards that prima facie case based on the notice on the certificate of service, that line of case law. We know that that won't satisfy this case because their prima facie case is we knowingly served the wrong person. This is a case where Moore and Midstream served the dirt, the grave dirt and the tombstone that he was in. They want us to believe that they know someone at that office looked at it and put it in the file. We can't know that. It could have been a child who opened that email. It could have been his widow. It could have been a nephew. Anyone with access to that email could have looked at it. There's no way to know. That's what the record shows. And does the record show that discovery wasn't done? It does. On the reporter record, page 13, 8 through 12, the trial court said, yeah, to Mr. Downs when questioned on this, yeah, nothing was done because their counsel was dead. That's why nothing was done. The trial court took judicial notice that Mr. Ogle died in December. It's an undisputed problem. This is the problem of the case. It is noticed at the start, but it does reach to adequate discovery once she gets a hold of it. Either way, the case makes no sense. It's literally a case where Ms. Pleisance is being penalized and the stand-ins are being penalized for showing up to court. That doesn't make a lot of sense for the law. And I think that this is the prime example of the difference between cases like the Emanuel case. There is evidence that there was something wrong here from the beginning. Thank you, Your Honor.
All right. Thanks to both sides. This case is now submitted. All right, call the next case, 1424. 1428-00828 CV, Joan Daly versus Peter, forgive me, Laley? Laley.
Got it right.
All right. Both sides ready?
Yes, Your Honor.
All right. Appellant, do you have any time you'd like to reserve for rebuttal?
Reserve 5 minutes for rebuttal.
All right. Please make your way to the lectern, and when opposing counsel seems to be settled, go ahead and begin. Go.
May it please the court. My name is Antonio Xavier Milton on behalf of the appellant, Ms. Joan Daly. This court should reverse the trial court's denial of Ms. Daly's motion to dismiss for 3 reasons. First is that Mr. Laley has failed to produce clear and specific evidence that Ms. Daly acted with actual malice. Second is that he also failed to meet that burden with respect to whether or not Ms. Daly published a false statement of fact at the March 2024 HOA meeting. And then third is that his IIED claim should be dismissed because it's duplicative of his defamation claim. And subject to the court's questions or guidance, I'd like to focus exclusively on the first 2 points with respect to the defamation claim. And it's particularly about point 1, the fault element. Actual malice is truly all this court needs to address in order to dispose of this case, because Mr. Laley failed to provide any evidence of actual malice as to the specific implication or insinuation that he now advances on.
Actual malice is defined as a reckless disregard, correct?
That is correct, Your Honor.
And if I recall, your client said as a former teacher, so added that phrase before, as a former teacher, I have a duty to report. Is that correct?
That is correct.
And as a former teacher, I have a duty to report. That tells me she's referring to criminal conduct, right? Teachers have a duty to report criminal conduct of which she alleged Mr. Laley to have committed.
Your Honor, so that is not actual evidence going towards actual malice. So it's about the relationship from the speaker to the truth. It's not about, and what I'd say, that's more so towards my second point, which is whether or not there's a statement of fact being published.
You talk about the relation to the truth, but didn't she subsequently apologize, at least to some people, for the statements?
So, Your Honor, evidence of a party apologizing or retracting when confronted with outcries or allegation of defamation is not evidence that goes towards actual malice at the time of speaking. And I can direct this court to the case of Freedom Newspapers of Texas versus Cantu. That's a case in which there was allegations of there's longstanding ill will between the speaker and the defamation plaintiff, and the publications made by the defendant in that case, and the retractions and things that they had done after making that publication were evidence of actual malice. And the Texas Supreme Court rejected that argument and said that's not evidence of actual malice. And even this court's own precedents in 2018 in Rodriguez versus Gonzalez, there was a similar kind of allegations of similar comments that would fall within defamation per se, allegations that a party or a plaintiff was a thief, a wife beater, and a deadbeat. And that this court, Chief Justice Christopher's name, Chief Justice Christopher said that simply showing that those statements are false is not enough to show actual malice.
But she knew why he was taking the pictures, yes?
Well-
I mean, she knew that the rules violations were the
So, Your Honor,
disputed.
Mr. Laley's own evidence doesn't show that she knew that. Because actually, if you look at, I have the exact site, page 86, this is the appendix. Page 86 in our appendix, it's one of the exhibits attached to Mr. Hooper's affidavit. It shows that she says that Mr. Hernan, the tennis pro, is not violating any deed restrictions. So actually, these statements that show her subjective state of mind, which is all we're concerned about when it comes to actual malice, it shows that there are no violations going on. And so,
Okay, but I mean, we knew, you know, with the whole, you have to look at the whole
Sure.
circumstance. And
Sure.
you know that it's a pickleball versus tennis situation. We know what we're
Absolutely.
fighting about. And so we know that he is knee deep in that issue.
sure.
So, I mean, we can't, it kind of seems like you're saying we have to look at this in a vacuum.
Well, no, Your Honor. You actually look at, if you want to look at the entirety of the circumstance, you actually see that Ms. Daly is merely republishing the concerns of other parents and people who have witnessed this activity.
Except she added the additional phrase, which I see no relationship at all to his limited purpose public figure of taking over pickleball in that HOA.
So, Your Honor, he's a limited purpose public figure with respect to usage of the courts. And it's, whenever we look at the limited purpose public figure analysis, we examine in Macklemore whether a person has thrust themselves into the limelight. Mr. Leal, by going to a place where there are children present and taking photos, has done that. That's what happened in Macklemore with the Waco raids. The individual who was present there, who injected himself into the scene, is then considered a limited purpose public figure, at least for that purpose. And that's exactly what happened here. So his status...
But him thrusting himself as a public figure, does that mean that it is allowed for him to be accused of a sexual improper photography of children, which is the implication your client made when she said, as a former teacher, I have a duty to report. That's criminal conduct that, in my opinion, bears no connection to Mr. Leal, if I agree with you that he's a limited purpose public figure.
Sure. So, Your Honor, two things. That would only be true if he's bringing a defamation by implication claim. He is not. And I'd like to shift gears to that for just 1 second, because, again, that's not, the existence of those facts and her statements that are made, those aren't evidence of actual malice. And I'd like to point, in Lane v. Ferris, the Fort Worth court said that just because a party later on, this is, again, I'm going to reference the reprimand meeting that I believe Justice Bridges had mentioned, just because a party then backtracks and doubts after receiving public backlash or pushback, that's not evidence that at the time of the speech that she knew or had reckless disregard for the falsity of her speech.
But what about the comments made, I believe it was the HOA president, Mr. Hooper, I think, in the affidavit saying, I told her what this was for, and it wasn't for some nefarious purpose.
So, Your Honor, statements, innocent explanations of conduct, back to that Freedom Newspapers case, that's not evidence of actual malice either. Because
But
of the
we're not on a jury trial, we're not reviewing a jury
Sure.
verdict, we're not reviewing a summary
Yeah.
judgment. We're just wondering if you can go
Yeah, absolutely.
forward.
Yes, Your Honor.
And so that seems like a major difference between
Well,
our
Your
case
Honor,
and those.
if the sum total of a party's show of evidence at the TCPA motion to dismiss stage is comprised of speculative or legally impermissible or incompetent evidence, then they shouldn't be allowed to advance past the TCPA stage. This is clearly, as Justice Antu has kind of latched onto, we're talking about a heated public debate about the usage of public community resources. And there's substantial evidence in the record that this is a contentious debate where some citizens in the community feel that they're not heard, feel that they're not listened to, and that includes parents and Ms. Daly herself. And that shouldn't be a basis for this court to say, oh, there's enough here. I think,
Wait, but you're saying they feel like they weren't heard about the pickleball versus tennis issue.
well, not
Right?
necessarily, Your Honor, because the tennis committee reports for both January and February, and I'd like to point this court, I believe it's page 86, 87, 88 of our ALCR or our appendix. It shows that it's not just the tennis v. pickleball dispute. It's also the fact that multiple parents have raised these concerns in these committee meetings where there are,
What
say 20
concerns?
people.
The
The concerns that there are
pictures.
adults taking pictures of kids repeatedly over a long period of time, especially whenever there's, and again, when we're talking about my client and her mental state, when she's making these assertions, just because, when we talk about her mental state, she's showing that the innocent explanation that's given by Leal and his supporting affiants, if she doesn't believe that innocent explanation, that doesn't show actual malice. Again, that's not what the actual malice inquiry is about, is deterring calculated falsehoods. I think this court and its sister court, the First Court of Appeals, has said time and time again, a party's speech can be inartful, it can be offensive, and it can be harmful, and yet it's not defamatory. And this
So
is such a case.
What evidence could he present on a TCPA motion of actual malice
Certainly.
that would satisfy?
Sure. Evidence would be if he approached her and said, hey, here are the uses for the pictures, and it's all shown that, hey, there's nothing improper here, and then she continues to go out and make that. Or what also could be done is if she had no other community reports, like if she didn't have in her attendance reports this consistent cycle of individuals in the community saying, hey, we're uncomfortable about this happening. If she made that up entirely, then that would be evidence of actual
But how do we
malice.
know if she made it? I mean,
Sure.
how would we know? And
Yeah, how would you
doesn't
know
that
is that from the plaintiff's or non-movement's show of evidence, that wouldn't exist. Here in the plaintiff's own show of evidence, this goes back to kind of how Mr. Leal on appeal has attacked Ms. Daly as trying to, twist the TCPA standard. We're not doing that. We're pointing out the holes within this show of evidence because it's not sufficient for a party just to, by volume say, hey, I've got volume of evidence, I've met my clear and specific evidence standard. It doesn't matter if I've shifted my story over the course of time. It doesn't matter that things conflict or that they're conclusory. Instead, what that would do is defeat the exact purpose of the TCPA, which is designed to have quick resolution of vexatious lawsuits brought to curb speech and chill First Amendment expressions. I think protecting children and protecting the courts is something that Ms. Daly was tasked with doing as chairperson of the courts in the HOA community. And so I don't believe that the record that in terms of the evidence that Mr. Laley has produced showed actual malice. At most it showed competing allegations of what might have happened, but nothing that would have substantively raised doubts about her speech before the March HOA meeting.
So does the record, if she felt strongly enough to say that she needed to report these acts of child exploitation, is there anything in the record to show that she actually ever did that?
Well, Your Honor, there's nothing in the record from what I can tell. However, what I'd like to say is that and then this moves into the second point that I've raised about a statement of fact being asserted here. So what this court has to do is detach and disregard these statements that she implied or insinuated that something has happened, because Mr. Lely on appeal has absolutely disclaimed that he's bringing an implication claim. So I'd like to steer the court towards the kind of timeline of pleading in this case. Well, first, he's kind of shown, he initially filed a lawsuit saying she expressly named me and called me a pedophile. The TCPA motion is filed. I also realized that my time is up. I'll just conclude by saying that he's shifted courses over the course of time to lower his burden. And he still has not shown an express statement of fact. He's only done so by editorializing the little statements he's put forward in one or two of the affidavits, and that's just not sufficient because it allows a party to shape-shift their claims at different stages and simply point to their supporters and say, hey, I've got a volume of evidence, we can keep beating down on the minority position or someone who we don't like in our community and continue subjecting them to vexatious litigation. And I'll be back with my rebuttal.
Thank you, sir.
Questions.
Apologies, may I grab one of the water bottles, actually?
Do y'all need some more water over at the table? Y'all good? All right, thank you.
Good afternoon, Your Honors, and may it please the court. The TCPA, of course, is set up to make sure frivolous lawsuits are not filed to quell speech and to chill speech, but it's also set up to ensure that meritorious lawsuits make it through. Before I get into the actual evidence that supports the elements of the defamation claim, the IIED claim, I want to talk about three concepts that are critical for framing this entire appeal. First off is the legal standard. So the only question right now is there clear and specific evidence for each element? That clear and specific evidence is not the same as what's required for summary judgment. This is not a trial. We're not in front of a jury. All that's asked is, can a rational inference be made from the pieces of evidence that we've provided at this stage, that if that was presented to a jury, if it was assumed to be true, and if it's not contested at all, is that enough for a jury verdict in our client's favor? We would say absolutely. Circumstantial evidence is perfectly valid. You do not need direct evidence. You don't need a direct admission from Miss Daly that I knew this was false and I said it anyway, although the record shows we actually are very close to that. Circumstantial evidence is perfectly valid, and I want to remind the court too that all evidence, just like on summary judgment, is viewed in the light most favorable to my client, Mr. Laley. So if you got any doubts about which way the evidence might go, and I think it's clearly on our side, it's still going to go our way because it's viewed in the light most favorable to my client. Yes.
So, what about the evidence that that she had these reports from community members about somebody taking pictures?
Sure, Your Honor. So if there were reports made by parents of why is this person out here taking pictures, there could be any number of reasons that parents are concerned about that. They don't want their children's name, image, or likeness posted somewhere, or why are their pictures being retained. There's no suggestion there that the parents are necessarily worried about pedophilia or sexual exploitation. But what Ms. Daly does is, and I'll get straight to the record on that, she goes to the board for 2 separate meetings leading up to the meeting in question, puts it on the agenda, someone's out here taking pictures, I'm concerned about this, and then she gets a direct statement from Mr. Hooper, it's in his declaration, he's president of the board, he says, look, he's out there to take pictures of the violations, the court policies. We've got new court policies, you're supposed to, these are the times for tennis, these are the times for pickleball, you're not honoring that. So he's out there taking pictures. Miss Green, who she called on the phone, and Miss Green says in her declaration, I just don't think an adult man should be out here taking pictures of children. Miss Green says we sent him out there.
And so this is all before this.
This is all before. This is 2 to 3 months leading up to this board meeting. And Mr. Laley himself in his declaration says, when I was out there taking the pictures, Miss Daly had concerns, so what are you doing? And he specifically told her himself, I'm here to document your court violations. So 3 times she's heard it now before the meeting in question. And then she shows up at the meeting in question, and what does she do? Well, according to Mr. Laley's declaration, it's right there. He says, quote, Daly accused me of taking photographs of children for inappropriate purposes. That's right out of his declaration. Then he says again, well, how did she do that? Quote, stating at the meeting that I took pictures of children on the tennis courts for inappropriate reasons. And when we look at Hooper and Green's declarations, they say that in the context, she sets this whole moment up with this statement. I just need everybody to know, I have a duty to report instances of sexual exploitation of minor children through photographs and videography, end quote. So that's Hooper and Green both saying that's what she said, that's the context for her statements. And Green also says in her declaration that Miss Daly, quote, referred to the pictures that were taken by Laley. So she's identified Laley and the pictures he took. She said, I have a duty to report an instance of sexual exploitation of minor children, and according to Laley, accused me of taking photographs of children for inappropriate purposes. You put all this together in the light most favorable to my client, circumstantial evidence, the whole standard at issue, clear and specific. If a jury accepts all that as true, we have defamation.
So why not bring the claim that Mr. Milton said you should have brought?
Which is which claim?
Defamation by implication.
So defamation, this is a helpful thing. So this comes out of Tatum. Tatum is a libel case. So Tatum walks through the entire law to clear up some issues of the difference between textual defamation and extrinsic defamation. And this is critical because it's a libel case. It's written in the 4 corners of a document, a script, a published newspaper article. It's not a slander case. So in those cases, the court walks through the analysis. There's a whole decision tree here. You have textual defamation, which can come in 2 forms. It's explicit. It's right there on the face of the page. That person took pictures of kids. They're a pedophile. They're a sexual predator. That's explicit. Also within textual defamation is implicit or implied. So maybe they don't name the person. Maybe they say the person that was there last week on the courts So you have to look for the implied meaning within the context of the whole thing that's written. Outside of all of this, you then go to extrinsic defamation. So the distinction between express or explicit and implicit is critical for looking at a libel case, not a slander case. A slander case, and we've cited the authorities, Morrison being the main one, you don't have the written word. You don't have the four corners. You can't look at explicit quotes. So what do? You ask witnesses, and witnesses share things from their memory. And all that's required is that they express what the substance of the statements were. They don't have to verbatim quote it. And that's right there in Morrison, because in Morrison, the jury charge had a quoted statement and asked the jury, is this what the person said? And the jury said, well, no, we don't think that's exactly what they said. Well, the Court of Appeals reversed and remanded and said, you've got to do a new instruction because all that's required is the substance.
Couldn't that be the same in slander? You know, I mean, it seems like implication versus explicit is...
Exactly. So in slander, what you would do is you would ask witnesses, what was said? Can we grasp what the substance is? Let's piece together the witness testimony. And is this express? Is this implied? So maybe she doesn't name Laylee by name, but she says the chairman of the pickleball committee, or he's sitting on the front row when she's talking and she points at him or looks at him when she's talking about the pictures. Those would be implied situations.
So you are...
We're bringing both claims.
Okay.
Explicit and implied. We have not renounced bringing an implied claim. What we try to argue in our brief is this is more than an implied defamation claim. So this is not just an implied defamation claim. This is an explicit and an implied, and it doesn't make any difference which one it is because the record has ample evidence to meet the clear and specific standard here.
I think it makes a difference if there are different burdens. Would you agree?
I think it would make a difference for the burdens at trial or potentially at summary judgment, but for the clear and specific issue, the only question is the kind of evidence we've brought to set up the kind of defamation, which is the slander as opposed to libel, is that sufficient? And all we have to do is show the substance of the comments, not a verbatim quote.
So your clear and specific evidence of actual malice is that she had been told 3 times before that it was the rules violation.
Yes, Justice Boatman. So the secretary of the board, Ms. Green, had a phone call with Ms. Daly when Ms. Daly said, I don't like adult men out here taking pictures of kids. Well, he's taking pictures for rules violations. Mr. Laley told her that when he was out there. Mr. Hooper told her that.
So you're not relying on the apology after the fact?
Yeah, and also the apology. So after the fact, we've got the apology. So both Hooper and Green are in the room. There's a third person there from the board. They're talking to her. They confront her. They say, look, what are you doing? Why did you say this at the meeting? And she says, according to their declarations, quote, I was wrong about Laley being a pervert, pedophile, or sexual predator. And that reminds me that those 3 Ps, the pervert, pedophile, and predator, that's the implied defamation, if you want. So the implication of the statements, he's taking pictures for inappropriate purposes, and it's an instance of sexual exploitation. The implication is calling him a pedophile with actual facts to support it. So that's the implied defamation. But yes, after the fact, she admits, according to their declarations, I was wrong about Laley being a pervert, pedophile, or sexual predator. I don't know how you get better circumstantial evidence of a person's intent and malice than what we have here.
So what do you do about the fact that it's after the fact?
So after the fact, the cases that counsel cited there for after the fact are when at the moment the statement is made, there is not knowledge or reason to believe that the statements you're making are false. But after the fact, you learn that information. And then you say, oh, I didn't know that. I'm sorry. Well, here we have 3 instances of being told specifically why he's out there doing what he was doing. And she still rushes through, makes her defamatory comments, and then also apologizes after the fact. So the apology solidifies the knowledge she had beforehand, which is, I knew what I was doing. I implied that he's a pedophile. I said what I said about sexual exploitation. And yes, that was wrong.
Were there any other times that there were rules violations not pertaining or that had nothing to do with children? Is there anything in the record about that?
So, Your Honor, I can't speak confidently about the record on that. I do know that there were significant rules violations about locker room usage, a tennis pro coming out there who wasn't paying any commissions for use of the courts, and that some of the lessons were children's lessons. So All we know is the documented times were the ones that had kids during kids' tennis lessons. But whether or not there were numerous other instances of adult lessons, I don't know that from the record we have. If I could have just one moment to review my notes. I also want to mention, the Montano case we've cited multiple times. We believe it's nearly on all fours as far as lining up on each of these issues. It's a slander case. It's the same kind of allegations of taking pictures of girls, you pedophile. That's the statement that's yelled out in front of people. And in that case, there's only one affidavit. It's the plaintiff. The plaintiff submits one affidavit setting forth all the allegations. That's clear and specific evidence sufficient to go forward.
What did the plaintiff in that case say about actual malice?
So the plaintiff in that case was not a limited public figure case,
Okay.
and we haven't made a big issue of that. We don't think it's really necessary. We win even if you apply the highest standard. But in that case, it wasn't a limited public figure, so all that was required was negligence.
Oh, I see. Okay.
And there was a rival rowing league instead of a rival pickleball tennis usage. The other thing I want to say about the standard here is under Tatum, it discusses, when you're looking at statements and trying to interpret their meaning in a libel case, and we believe this principle would apply in slander, and the statements are ambiguous, that's going to go to a jury. So even if you think the statements here are ambiguous, but could reasonably be interpreted as defamatory, that's going to go to a jury, and we get past the TCPA. If it's good enough to go to a jury, it's good enough to get past the TCPA. And so we win today if the court decides the statements were defamatory, according to the declarations, or that they're ambiguous and could reasonably be interpreted as defamatory under the declarations. So we think combining all that together, we should be permitted to proceed forward with trial. In the last bit of my time, I want to mention the IIED claim. So here, there's broader conduct than just the defamatory statements made on that March 25th board meeting. There's instances of Ms. Daly calling Mr. Laley a chauvinistic pig and discriminatory. In the pickleball committee meetings, she would often disrupt the efforts of the pickleball committee to present their policies and guidelines and what they wanted to do with the court usage. She harassed Daly for trying to do his job and document with the pictures he was taking. She lied about line painting. When a vendor was supposed to be called in to paint the lines for pickleball, she said she would handle it, purposefully delayed all that, and then threw Mr. Laley under the bus and blamed him. After the statements are made, she refused to apologize. The board sent her a letter asking for her to apologize publicly because there were 50 people at this meeting. She refused to do it. She's the only person with a copy of the letter other than the board members. She leaks that to a friend who posts that on Facebook. It names Mr. Laley on there, mentions her comments. So this whole host of conduct goes way beyond just the defamatory statement made at the meeting.
But is that conduct otherwise actionable? And this is the problem with IAD. If it's not otherwise actionable, then can you just bring this as a gap filler tort? Because there's not a tort for it because it's not actionable.
So that's a good question, Justice Boatman. So what we would argue here is that the defamatory statements alone are actionable, but then there's additional harm from all the conduct that was before the defamatory conduct. And so that conduct there is actionable independently and separately, even though it also includes the defamatory statement. There's harms that stem from that whole host of conduct.
Isn't that damages rather than, you know what I mean? You're saying that there were additional damages, but is there an additional claim based on those?
Well, I think potentially there could be a causal problem with damages if it stems from her calling him a chauvinistic pig, if it stems from her disrupting the efforts of the pickleball committee, if it stems from things that happened prior to the specific defamatory
But I don't think we
statements.
allow an IAD claim just to allow more damages, just to get around a causation problem.
My understanding, Justice Boatman, is that both claims can proceed forward if the conduct is sufficiently different, even if it encompasses some, if it's sufficiently different so that it fills the gaps where defamation doesn't grab that. And if there are...
But I guess, here's my question.
Sure.
Excuse me. The line painting thing. If we just said there wasn't defamation, I mean, if there wasn't defamation, you couldn't bring a claim for I don't remember exactly what you said, but, delaying
Yes.
repainting of the line.
So there were delays. She said that Mr. Laley was responsible for it when she said she would take control
But
of
you
it.
couldn't bring that claim, right, if it weren't for these public comments?
I think that claim could be brought as extreme and outrageous conduct when you put it in the whole package, even aside from the defamatory statements made at the March board meeting. When you put it in the whole package of disruption and antagonizing him and blocking the efforts of the pickleball committee, lying that he was responsible and failed to do his duties and obligations, I think that could potentially be brought, go to a jury, and the jury would decide if that constitutes extreme and outrageous conduct. And of course, we would have to have an expert engaged to prove up damages. So our position here is it's just too premature at this stage. We've got enough in the declaration to show a whole host of conduct beyond just the defamatory statements. And we also have statements in the declaration about how it harmed him, which of course we would have an expert and other evidence in the future, but that's not required at this stage. If your honors have no other questions, I'll finish my time. Thank you.
Thank you, sir. Rebuttal, sir.
So I'd like to begin by kind of clearing the air because in Mr. Laley's respondent's brief, I believe it's footnote 24, either note 20 on page 24, he says that the defamatory nature of Ms. Daly's comments were explicit, not implied. He's expressly said that he's not at all advancing a defamation by implication claim. So any kind of statements that are saying, oh, well, we understood her comments to mean X, or she insinuated, or she implied, are not evidence that go towards whether or not there was a defamatory statement of fact being published instead of some other kind of figurative or disguised opinion or something else. Or again, it might be what I've kind of alluded to before, which is inartful speech that could be offensive, could be harmful, but is still not defamatory. And I'd like to respond mostly to the actual malice, I guess, arguments that have been addressed here in this case. Again, counsel for Mr. Laley walked through these previous instances in which Ms. Green, Mr. Hooper, and Mr. Laley had gave their version of events of Mr. Laley was only taking pictures to document rule violations. Even though there's evidence in Mr. Laley's own show of proof in the form of the affidavits he's attached, and also within the statements of Mr. Hooper and Ms. Green that show that she has equally competing other reasons not to believe that. And then second, Mr. Hooper and Ms. Green don't actually have personal knowledge of all the uses of all the photographs. And again, I think if we look at the affidavits, specifically the tennis committee reports that Mr. Laley was just referencing, if you look at ALCR 84, 85, 86 through 88, these are the committee reports for February and March, the 2 months that happened before this March HOA meeting. You see that it's crystal clear that there is just discord and disconnect between the tennis community and the board. And I would say that if board members are saying, oh, there's only one reason for this, it doesn't show that Ms. Daly should be like, you're right, and accept your innocent explanation of events. Again, I'd like to steer direct this court to the Freedom Newspapers case. Again.
So, and let me narrow that for
Sure.
you. Opposing counsel came up here and, without saying Freedom Newspapers, just distinguish that case from these facts. I want to hear your specific rebuttal.
Sure. My specific rebuttal is that Freedom Newspapers is these facts. You go up and essentially you have an innocent explanation for your conduct. In Freedom Newspapers, it was the fact that a candidate was saying, no white person could be sheriff of this county. And there was a question about whether or not how it's been selectively editorialized, his statements. And then he offered chances to clarify the error. And by saying he offered his innocent explanations, saying that, yeah, I didn't mean that no white person could ever be sheriff. I just mean you gotta know the community. And they still continued to publish things that said that no, he was exclusionary, expressing exclusionary views. And so again, we have these statements which happen before a party makes a publication, and it's not evidence of actual malice. And then I'd even like to go to the Fort Worth Court of Appeals decided in Lane v. Ferris, it's 544 Southwest 2nd, 881, at page 895. A subsequent retraction when confronted with evidence to the contrary is not evidence of actual malice. And this is the quote from the court. That the speaker later questioned her previous belief when confronted does not show that at the time she made the statement knew it was false or that she had a reckless disregard for the truth. Again, the evidence that Mr. Leal relies upon in these three, his affidavit and his supporting affiants, don't show that at the time that she would have made the statement that she was aware that the community would take this kind of gist away from her comments, or that she even that knew that it would be false. So
I mean, she said as a former teacher, I think that you would know what the community was gonna think about that.
well, Your Honor, not necessarily, because what we're talking about, and the context, and this also goes towards the statement, the context is heavily edited. And it's strange because in their own show of proof, Ms. Daly talks for 10 minutes, and we only get 2 sentences of what she said. Again, I think it also, I'd like to direct the court to...
But I think, and I'm piggybacking on Justice Boatman's question, you know, if I walked around and I said, well, as a judge, I think you're wrong. I mean, that carries a lot of weight behind it, because that tells whoever is listening that I'm in a position of more knowledge, experience, you know, whether that be true or not, it may not be true. It gives that credence to the statement that comes after that.
Well, Your Honor, the one thing I would say is that, but only go to the evidence of whether or not there's a statement of fact being published. And one thing I'd like to actually address with respect to, I see I'm out of time, the facts and evidence that we have here, under the Texas Defamation Act, actually, this would not even be admissible evidence at trial. Her apology, nor any other attempts to get her to apologize or retract after the fact, pages 93 through 96, she sent a written letter saying, you have said false statements of fact about this person for this reason, this reason, this reason, and then she is coerced into saying, yes, I apologize, because she was literally forced to say either you have to apologize or give up your spot as chair of the courts committee. And so that wasn't freely given. And again, summates that Mr. Leal is basing his evidence of actual malice on things that are legally insufficient to show that she either knew or had a reckless disregard for the falsity of her statements at the time of the HOA meeting. And so, without any further questions, because Mr. Laley has failed to meet his burden with the TCPA, this court should reverse and remand for consideration of Ms. Daly's attorney's fees. Thank you, Your Honors.
Thank you, counsel. Thank y'all. This case is now submitted. Thank you for your time. Have a good afternoon.